A train reactor spitting fire. The NFT analyzer, diving deep into projects. He's the crypto energizer. From your meme coins to tokens, he's got all the intel. Web3 wizardry, he'll show you where to excel. He's got the insights like a digital magician, unveiling secrets.
All right. Here we go. Happy Friday, fam. Edge, Choina, Cosmos. Good morning, sirs. Hey, I got a fun show for you this morning. Do you guys... I'm actually itching to know. Do you guys like Polly? Yeah, I like the guy. Dude, total scumbag, but... Yeah, whatever. Me too. Me too. Polly's back, guys. Polly, right from Pepe Coin, or just Pepe, and the Pond Dex, and the Pork Token, and the Thorn and Yuga Labs side. Apparently, and I don't know if I believe this anymore, but apparently one of the creators of ApeCoin, which sounds pretty crazy, but I do actually think, I don't know. At this point, you can't tell what's a grift or not. But I think Polly was actually involved in creating ApeCoin. He used to say he was, and I didn't see anybody actually like refute it. And it could just be because people are so over his bullshit. They're like, whatever. But I think it might be true. It actually might be true. Cats, good morning, sir. All right, to kick this off, fam, want to put you onto a couple giveaways here. First off, over on the CryptoSlam account, guys, CryptoSlam.io over on X. A giveaway of a Powerup NFT, which is pretty fantastic. A lot of you have one already. This is separate from your claimable NFT. Right, so you have the Thunder Passes already. The giveaway here is for a Power-Up. They go hand in hand. We're going to announce that utility here pretty damn soon. But definitely get in on that contest. You just got to follow these few accounts here. The CryptoSlam account, SlamX, SlamNet. You see here, like it, retweet it, tag a couple buddies. If you have a Power-Up already, guys, this will actually upgrade it to Legendary. And trust me, you want the Legendary version. You do. It's got a cool perk. I know. I happen to know what it is, guys. I do. And as much as I want to say, and usually I'm pretty stupid and give those spoilers, I'll keep this one. I'll keep this one until it's officially time to go out. But heads up about that. Get that tweet. Actually, let me drop that in the chat for you, fam. Get in there. Also, hey, I finally found my wallet that has my my Adidas stuff, right? My Doodles TV. Speaking of which, Doodles dropped the song today, the Coi Leray Not in the Store song, right? It's on YouTube, it's on Spotify, it's everywhere. No longer exclusive over on Doodles TV. So glad I found it. I got a couple packs, right? Because they got that exclusive Adidas merch. I'm going to crack those open live here. And if we hit something cool, if we hit some of that exclusive merch, we'll give it away to somebody tuning in here. So we got 2 chances of that. I might actually buy a couple more. I'm addicted to cracking packs. So we might have a couple more to give away, which would be pretty damn cool. So stay tuned for that. I don't know if we're going to get to that early. If we get to it, I don't know. You know, I'm just going with the flow here. I do want to get to some more macro stories. I want to touch on NFTs, which, by the way, guys, I hope you're feeling what I'm feeling, but I'm feeling some energy coming back to the market. Even if you don't see it in volume yet, it's a sentiment thing. And I'm definitely feeling it, guys. I definitely see people talking about NFTs, excited for them to come back. Tired of meme coins, to be honest. People are tired of them. You know, I don't feel tired of them because I didn't trade them. In fact, it's just now that I'm starting to get into meme coins. So I'm kind of opposite here, which kind is good and bad. With that said, it's very clear out on X. People are really wanting and willing NFTs to come back. So it really is. Tell you what, it bodes well for what's coming here. The fact that people want it to happen, even at the prices this stuff's still at, which I might argue is still kind of expensive, but it doesn't matter what I think. At these prices, people still see great opportunities. And so because of that, so do I. Good morning, brother. Good to see you, man. Okay, so the CryptoSlam giveaway, the The Doodles packs giveaways, like I'm not going to give it away if there's nothing cool in them, which, okay, it's all cool. But if we hit the merch, which is all limited edition, like 200 edition, there's shoes, there's like tracksuit, cool shit. If we hit any of those, it's going to you guys. We'll figure out how to do that contest. Probably just a retweet giveaway. But guys, we got CPI readings earlier this week. Looked good. Looked good. We were also looking forward to the to Walmart's earnings report. Same with Alibaba, which I'm not sure. Maybe we peek at that live. But Walmart, earnings up, looking really good. Guys, stock hit an all-time high. So Walmart sales looking strong. Predicting or projecting more revenue now for the rest of this year. Looking really good. All great indicators for the economy. Not having any impact on the crypto market yet, guys. None. And that's okay. That's totally okay. I still think nothing is really noteworthy happening right now. It's just churning here till we get to November. November's the date where really I think this market picks and chooses what way it's going to go. I only see, being really honest here, I only see one outcome here. Unless these words that are being spoken here about crypto by politicians, unless it's totally empty and things change and all of a sudden we get a strong crypto crackdown. I've not ruled that out, by the way, as much as everyone has talked and signaled that everyone's pro crypto now. I don't have a lot of trust in me about anything. So we'll see about all that. Point there, I don't see any major movements for crypto here for a while. And I still want to put some emphasis on Mt. Gox. There's still a few $1 billion worth of Bitcoin to be sent out to creditors. I still don't know that once that Bitcoin has actually hit exchanges, I don't know that it has reached people's hands yet, the actual creditors, the people who were owed that money. And I don't think we've seen its impact on the market yet. I don't think we have. So it's a word of caution here that we still could see billions worth of Bitcoin dumped here, and still the FTX repayment. That is to me, that is the biggest catalyst of 2024 here. Other than the election, it's the FTX repayment. We still don't know if it's going to be cash or if it's going to be credit, guys. Crypto. If it's crypto, great. If it's cash, even better. If it's crypto, I don't know, that you got a chance that that's liquidated too, that's sold. And guys, that's almost $13 billion that's getting sent back to creditors. That will have a huge impact on the market. Massive. Massive. Lemon, this is so mind-boggling to me, and still, I really dislike the reaction to it. I did not love hearing Kamala come out and say that they're going to somehow enforce a price cap on food. You know, like on the surface, sounds great. I would love groceries to be more expensive. I would love them to be cheaper. Let me say that again. I'd love them to be way cheaper. I don't know. You start putting caps on food prices, things get into territory that I've always been taught growing up, and this is things I'm working on as I get older. You know, thinking for myself a little more, but you don't want to do that. That steers us into territory I think we don't want to be. The government controlling everything. In fact, let them control less. That said, prices are out of control, man. Out of fucking control. And I'll tell you what, not to make this too political, I try to say that, often enough. I don't want this to be a super political show, but I was always taught that trickle-down model. I was, and I believed in it. Right? Feed these companies, feed those rich people, it trickles down. I don't buy that anymore at all. Right? I would hear there ain't going to be any middle anymore. I heard that all my whole life growing up. I didn't believe it, and I see it now. I see it now, and I feel it, and I know that's the truth. And I'm not sure I'm a believer in that trickle-down and trickle-down economics. I don't think I believe it anymore. I like the idea of it starts with the middle class and it spreads from there. I love that idea. In fact, I can picture how there's great overlap there or synergy with that and the idea of things being decentralized. There's something to it. In fact, it plays very much into the whole idea of these NFT collections we love, right? Reward your holders, reward those people. We think if you do that, they'll get a little spendy, a lot spendy. And it's a very, very interesting, newer way to redistribute wealth and profits. And that we think we will have a much healthier ecosystem because of that. It's the royalty debate too, guys. That is a part of this puzzle, this whole puzzle we're trying to figure out. Man, I wish we were pushing in that direction right now. And we are. We're testing no royalties. We're testing chains soon, abstract chain that enforces royalties. We're testing, and we're going to learn a lot here. But talking about the economy, it's I don't buy the CPI saying things are getting better. I don't buy it because I don't see it. I don't see it anywhere, man. I mean, This is tricky. Most people I know, I'll tell you, most people I know are not better off. I'm not talking about back when Trump was president. I'm thinking like even a decade ago. I don't know anybody better off. I don't know anybody that's doing much better than they were 15 plus years ago. I don't know. This, I'll speak for myself here, and this isn't a comment about what I do. I love what I do. But like going even back to my corporate career before working in Web3, I've been here for 3 years in Web3. Better off because of crypto? Hell yeah. Better off in general? Pretty much the same. Pretty much the same. Now that gets to a whole other conversation about other ways you improve, but I don't know anybody that's really that much better off. I don't. It's been a really, really interesting thing to live through, and maybe it's normal, but as far as the stories I saw growing up and history that was taught, people did a whole hell of a lot better, previous decades. So I don't know. Something feels very wrong. Yeah, Lemon, and that's the concern, right? With that said, I was always told that those policies don't work. I was always told and shown the examples of where it didn't work. I still wonder if there's a way to marry the two ideas. I don't know. I don't know. And I'm willing to, with how bad things are, I'm willing to explore. I am. I'm more open to it than ever. Yeah. Yep. And that's a good point. Look, I read that Subway has kind of an all hands meeting because their profits are just down tremendously. And it's because, man, a freaking Subway sub costs like 10 to 15 bucks. And nobody's buying them now, right? I think to some degree we have to take responsibility and we have to stop spending money on things like that and let them feel what it's like. Let them feel with their bottom line that it's not something we tolerate anymore. Yet we tolerate it. We do. So a lot of this, guys, a lot of this is absolutely on us. Yeah, Lemon, price fixing doesn't work unless you're willing for items to just become unavailable. And then they aren't financially viable with a price cap. It's a mess. I know that. I know that. And I don't think we're heading in the right direction, especially with either candidate here in the States. I don't. So really, a consequential election coming up to a degree. But I also think things unfold the way they're going to unfold regardless of the person. We'll see. We'll see. Tickle, good morning, sir. How are things in your world, Tickle? What's going on out in the world of Bitcoin and data? By the way, Tickle, could you send me a link to your giveaway? Because I think it's fucking awesome. I've actually played in it a bit, and I have a question about it. Tickle made this data, I don't even know what to call it. Tickle basically plotted like millions of data points, and he's given away like 1,000 epic. If you search through those data points, there's a seed phrase embedded in it, right? You find the whole seed phrase, you access a wallet with 1,000 epic. It's really, really cool. It's really, really cool. Yeah, Tickle, drop them. Love to cover them here. Now, what I really want to do today, by the way, guys, smash the like, drop some comments in the video, share it out, all that good stuff. At the very least, throw a like on it. It helps a lot. It really, really helps, especially now it's slow out there. People just, again, like we've been saying for a couple of weeks, people enjoying the end of the summer. My kid's back in school this week, but other people just enjoying their last couple of weeks here with the fam, with the kids, all that stuff. Well, I like this time of the year. I like a slowdown before we start cooking because, hey, I think that cook's coming. NFT market, man, volume, while low, it's the best we've seen in a week here. Here's Sorare at the top of the collection rankings. Actually, worth mentioning, Sorare, who I absolutely love, their 24-25 season kicks off today, and I would imagine that's live right about now. So this is fantasy soccer specifically here. Kicks off today, sales ramping up right around this event. Right, people setting their lineups, getting all squared away for these new competitions, winning ETH prizes and whatnot. It's good stuff. Love Sorare. D-Market. By the way, as things slow down, you really start seeing the kind of forever NFT products rise to the top. You do. You really, really do. Gamified sports, sports collectibles, with fantasy sports tied in. It's Sorare. Gaming skins with D-Market. I got to skip Guild of Guardians because I know it's a lot of wash sales in there, but Bored Apes and CryptoPunks and Pudgies, like top tier collectibles. So really then, if I'm looking at like the top 5, Sorare, D-Market, Bored Ape, CryptoPunks, Pudgies, it's the cream of the crop stuff out there right now. And I can throw the Unicornio collection in that conversation because it's a brand new mint. And of course, brand new mints that have hype are going to chart. So it's a really good representation about what this space is right here. Amazing quality as far as utility kind of NFTs, top tier collectibles, and then brand new mints. Makes a lot of sense. I like the leaderboard this morning. Okay, cool. Vrew, thank you. I'm going to check that here in a second. Now, what I want to get into today is, guys, Poly. Poly OX is back on X. He never left, right? These guys, mind you guys, all those top tier influencers, picture those guys you see every day on your timeline, all of them. They've all got burner accounts, right? All those guys are tweeting at you from multiple accounts. You don't know which others are theirs. But Poly OX, I think everybody knows him at this point, is back on X with one of his burners, and he was on a Spaces yesterday, and man, was the dude fired up. Man, was this dude fired up. So what I want to do today, and probably most of this hour here, is check out what it is Poly's into right now, why he's back, why he's making noise. And guys, it's because the Yuga Labs versus Ryder Rip's Bored Ape Yacht Club, right? That's Ryder Rips and Poly. It's back in the news. It's actually back in the courts. So there it is, the United States Court of Appeals for the Ninth Circuit. These guys are appealing their $9 million fine. And it's a really interesting, really interesting case here. I want to listen to, we'll go as much as it makes sense, but I think I want to listen to the whole thing here because, right, guys, this is all about IP. This is a very defining case here for NFTs and copyright and fair use, all that stuff. I want to listen to the whole damn thing and hear Yuga's side, Ryder and Poly's side. It's a really interesting listen. I've listened to it through now 1.5 times. It's super interesting stuff. So I want to play this and listen. We'll pause. We'll give some feedback and comments on it. But I definitely want to cover this today. It's interesting. Even some judge chiming in here. I thought this was interesting, pushing back on the Yuga Labs lawyer and saying, look, isn't it when you're buying it, like challenging him and saying, hey, when you buy an NFT, you're buying the token, you're not buying the art. Like you guys have this case about the art being a direct ripoff. It is. It's also, as Ryder says it, and Poly says it, it's a criticism of the Yuga collection, of the Bored Ape Yacht Club. And it is. And the judges are pushing back a bit and saying it is. And also at the same time, these things being sold are code. It's an NFT. People are not buying the artwork. Now, the Yuga lawyers push back on that too. And again, this is why it gets so interesting. So I want to check this out today. I want to listen. So, Vrew, let me peek at that. I want to peek at your DM because I think you and Tickler are zeroed in on the same project here. Oh, also, yeah, this is good too. I'm looking at Vrew's DM here. There is a big BRC20 airdrop coming. Yeah. This has been on my radar. And I bet you most of you qualify for it if you played in BRC20s, guys. Let me pull this up. Okay, this is coming. Hang on. What's the name of the BRC20, guys? It's called Sats Pump Fun. Is that the name of the token? By the way, they are launching. This platform is a pump.fun for Bitcoin, which I'll be honest, I don't want it, but also you can't stop it. But there is a big airdrop coming. They're calling it the first and largest BRC20 airdrop. Wait, hang on, guys. Clarify for me. How is this the first BRC20 airdrop? I mean, are they just being really specific, airdrop versus claim? That might be it. They may be saying it's their first airdrop. That could be. Anyway, to qualify, $300 worth of one of multiple BRC20s here. Ordy, Sats, Pizza, Shint, SHNT, Wizard, Honk, Rats. Or you could have 3 bitmaps. You have $300 worth of those tokens, though, you get this airdrop. Again, I'm looking for the ticker here. Tickle has been putting us on to a new fractal drop, first PFP. We probably won't cover that yet. Tickle, unless that's coming up next week. Right, unless we got to be aware of it right now. I don't know if we're going to cover it today because I want to get to this court case. And then remind me, I don't want to forget, but I definitely want to get to the Kraken packs over here on Doodles and give away. If we hit the merch, guys, I want to give that away. But let's get into the Poly stuff. Again, it's spicy. I'm going to play just a clip because I want you to see how fired up Poly was yesterday. I love it. I like it. I like the spicy stuff, you know?
Fucking Supreme Court. The court just they just saw the truth. It took years for that to happen. It took years for that to happen. And we had to fight for that to happen. With our whole fucking life. Fuck you.
By the way, this is after the case that we're going to watch here, right? This is after. And by the way, Poly shouting and saying they won. There was no winner yesterday, right? There's no ruling. They heard the case. This is probably being now sent to another court. This is going to continue. They heard their appeal. There was no ruling. There was no winner yet. Unless I've misunderstood something significant, there's no winner that I heard, having listened to that whole thing, again, more than once. But also, man, I have been scouring X looking for anything about this. Who won? What did they win? What was the ruling? There's nothing out there. It's just a bunch of people that are cheerleaders. They're like Poly stans, right? There's a lot of that out on X, but there's no info about any ruling here because I don't think there was a ruling. So I just want to mention that. And again, context for what this space was about and why so heated. Yeah, he's hyped that it felt like it went well. I wouldn't be so sure, but you'll see as we listen. It was the judges were it was interesting. They pushed back on Yuga a bit.
We just won. $9 million judgment. Suck my dick. We're not paying $9 million. Fuck out of here. We exposed your scam. And all it takes is a little bit of truth and fucking sunlight. It's over. It's over. And guess what? We already know we're fucking legends. But the
Poly looking great, by the way. Dude's shedding weight. Looks awesome.
world is going to find out, man. The world is going to find out about this shit. Steph Curry, fuck you. You're not an Olympic athlete. You're a fucking traitor. Take your fucking racist monkey pictures off your Twitter bio, you dipshit. How long did it take you to fucking delete FTX from your bio, dumbass? You're a fucking icon. People look up to you. Young people look up to you and they idolize you. And you're telling them to buy a fucking scam. Every big fucking celebrity in the world was endorsing this shit. Fuck Guy Oseary. Fuck Madonna. Fuck Greg Solano. Fuck Wiley Airnow. Fuck Tom Brady. Fuck Kevin Hart. Eminem. Snoop Dogg. Gwyneth Paltrow. Neymar. Fuck you guys. Fuck you. The truth comes out. And the truth will not fucking hide. As long as there's people that are willing to stand up for this shit, I told you we already won. Now we won big.
They didn't win shit.
Now we won big.
Again, I like the guy. They didn't win shit.
There's 731 people in here. I'm banned from Twitter. I'm banned from Twitter. This is what being censored and banned looks like. Censor me again, daddy. Censor me harder. Censor Ryder Ricks. Censor Ryan Hickman. Censor us harder. If this is what losing looks like, I want to lose every day for the rest of my fucking life. Go look at Forbes. Go look at Bloomberg. Go look at Reuters, CoinDesk, Cointelegraph. Go look at investing.com. They say I'm a scammer. They say we lost. Fuck you.
By the way, Poly ain't a scammer. I hate that narrative. And I hate that, again, this being back in court, the appeal happening yesterday, not a single one of those major sites covered it. I didn't see anything about it on Decrypt, CoinDesk, Cointelegraph. None of them covering this. And also, those guys are not calling Poly a scammer, but I see Poly's equals scammer everywhere on X. Man, I've followed the dude for a long time, and all the products he's involved in, all the tokens he's involved in, I've never seen him scam. I've seen him, man, very much make people a lot of money. Right? From pointing people to cool stuff early and getting them in his ecosystems. Yeah, I'm sure he's making money off it, but I think he's made a lot of people a lot of money too. I don't think Poly's a scammer. Tell me I'm wrong, but I don't think Poly's a scammer at all. Just a spicy character,
We just dominated. A couple regular ass motherfuckers just dominated a $4 billion crypto company in trademark court. They spent over $20 million on that shit. They wasted 3 years of our fucking life. Guile Siri threatening me, threatening my family, threatening Ryder's family, threatening Ryder's dad, Rodney Rips, threatening Ryan Hickman's family. Fuck you. We're real motherfuckers. And just because we're individuals, it doesn't mean you can fuck with us. We'll outbuild you, we'll out-art you, we'll out-meme you, we'll out-community you, we'll out-God you. What do you got? Money? What do you got? A fake fucking website? What do you got? Fake fucking followers on social media? Motherfucker, you don't have shit. This is where the real people are at. This is a fucking burner account. I got 742 people in here. I dare Yuga Labs to open up a space. How many motherfuckers are gonna pull up?
Dude, he ain't wrong. Dude, Polly ain't wrong. Yeah, it's one of the realest things out there. Again, it's a lot of Polly stands, but he ain't wrong, man. He's got a real ass community. He really does. He really, really does.
How many motherfuckers are gonna pull up? You're a $4 billion company? Who am I? I worked at a grocery store a couple years ago. This is a burner account. You pull up. You got 1 million followers. How many people can you put in a fucking video space, bitch? You guys are nothing.
Let's get to the court case. Let's get to it, because again, that's the real meat of it. Polly being back is a little side note, right? But this is fucking interesting, and this does have implications around this space. It is a conversation about art, about commentary, about fair use, about trademark. And I love again that the judge brought up an NFT. It's the code and it's the token, or is it the artwork? I love that conversation happening in a place where it matters a hell of a lot. So this matters a fuck ton. I can't fucking believe nobody's talking about it. And it's probably because there was no rulings, but again, nobody's talking about it. Weird.
All right, so our next case for argument is Yuga Labs versus...
By the way, I'll pause this somewhere at some point. We'll take a break. We'll crack open those Doodles packs just to keep things lively, right? We'll crack those open. We'll do that giveaway. Back to
Ryder
that.
Rips and Jeremy Cahan. And let's see, Mr. Tompros.
Yes, Your Honor. May it please the court, Louis Tompros for the appellants. I'd like to reserve 5 minutes for rebuttal.
Yuga Labs lawyer
possible. Here. This case raises several novel questions stemming from Yuga's abuse of trademark law to stifle freedom of expression.
Wrong. I'm sorry. It's Polly's lawyer.
Nevertheless, this court can resolve this appeal without breaking significant new ground by reversing on either nominative fair use or trademark ownership, which are the two dispositive areas which I'd propose to focus on primarily, though of course I'm happy to address anything else Your Honors would like. As to nominative fair use, the district court's decision directly contradicts this court's holdings in Carnes that fair use applies even if the alleged infringer's ultimate goal was to sell his own product, and Toyota, this court's decision that the plaintiff has the burden to prove that nominative fair use does not apply.
Let me ask you, how does this nominative fair use defense survive post Jack Daniels? What's your view as to whether or not Jack Daniels applies?
Jack Daniels is relevant to the First Amendment issue, but no court has ever held that the Jack Daniels First Amendment analysis is relevant to nominative fair use. And that's because what nominative fair use does is it replaces the likelihood of confusion test under Sleekcraft. So Jack Daniels doesn't change the nominative fair use calculus one way or the other, and there are no additional hurdles needed to jump over Jack Daniels to get
Jack Daniels also was applied to the dilution claim, correct?
Correct, Your Honor. That's correct. And this is not a dilution claim at all.
But it did kind of look to the purposes of the Lanham Act, that to ensure consumers can tell where goods come from. With respect to dilution, it was concerned with respect to with the ultimate question whether the use of a mark is similarly source identifying. Isn't that a relevant consideration here, whether or not the mark is similarly source identifying?
Well, respectfully, Your Honor, I think that it does. There is nothing in Jack Daniels that changes the existing nominative fair use requirement, which is that under nominative fair use, it is true that there is a burden on the plaintiffs to prove initially that they used the mark to refer to the trademarked good. That is, it's only nominative fair use if it names. So to that extent, I think that there is some potential relationship in that sense. Jack Daniels didn't purport to change that at all. And indeed, in this case, there is no question that the appellants used the marks BAYC, Bored Ape Yacht Club, the images, to refer to the Bored Ape Yacht Club of Yuga. In fact, that was an undisputed fact at summary judgment. Yuga Labs proposed, and it's in the record at 8 ER 1430, paragraph 70, Yuga proposed the undisputed fact. Defendants have stated that BAYC represents the abbreviated title of Yuga's NFT collection. We didn't dispute that. There was no dispute that Mr. Rips and Mr. Cahan were using these marks to name Yuga as part of their criticism of Yuga. And that's why nominative fair use applies. Now, the error that the district...
The problem with that for me is you're also using, your client is also using BAYC and the Bored Ape Yacht Club to refer to its own product that it's selling, its own NFT. I mean, it's embedded right in the name of the description of the NFT and also the contract name. So it's both, right?
For anyone not aware, by the way, this is the logo of the Reactor Bored Ape Yacht Club. Let me see. I think that site's down. I think they were forced to take the site down. Most marketplaces have blocked those NFTs. Let me rewind even a little more. The Reactor Bored Ape Yacht Club, it's a 10K collection. It is all the same art as the Bored Ape Yacht Club NFTs, right? It's literally a copy of it. And it is kind of, they call it like an art project, almost a performance art. It's critiquing the Bored Ape Yacht Club. It's also a comment or a statement about NFTs, them being the token, again, not the art. And then if you look at it through that lens, the art of the collection is the token. The fact that it is distinguishable from BAYC, the real collection, the Yuga Labs collection, and it's verifiable on chain. Again, a whole lawsuit around that, and Yuga claiming copyright infringement, mostly on the logo, right? Yeah, I mean, that's where it all stems from. There's a point Yuga tries making that, it's tricking people into buying those, thinking they're buying a Bored Ape. You'll hear the judges push back on that. But that's the collection. It's hard to find info about it because, again, it's websites forced to shut down. Marketplaces, again, delisted it. But that's what it is. I have a couple of them, by the way, so full disclosure if it matters, but I bought some. I like it. I like the idea of it. I like critiquing stuff. I like poking and prodding. I like us playing with definitions and feeling out, where are those lines. So I have a couple because I thought it was a fascinating story here, and it continues to be that.
Your Honor, it is. They are definitely using the name as part of the title of their own product, but that is allowed under nominative fair use. That's exactly what nominative fair use permits. It permits, for example, in the Applied Underwriters case, a company to call its program a program about applied underwriters. It permits, in the Toyota case, a repair shop to talk about the Lexus.
Let's see if I can find them in my wallet too.
Where they repair, and it permits, most tellingly, in
But in those cases, the factual context demonstrated that you wouldn't have confusion about origin.
Agreed, Your Honor.
And how is that the case here when the factual context is that your clients are offering on the market something that looks exactly the same as Yuga's product, and so you don't have a context that shows distinction?
So I think that, respectfully, Your Honor, we disagree. It was certainly a disputed issue of fact as to whether there was such a distinction. There were. If you look at the actual NFT that Mr. Rips and Mr. Cahan were selling, the text is different. It shows the creator name RRBAYC. It shows a different origin, a different creation date, different metadata. The database entry, which is all an NFT is, right? It's like the certificate in the name a star analogy that we used in our brief. That certificate was completely different, looks nothing like the Yuga NFT. Now,
What about, I mean, how do you explain away the contract name, which is Bored Ape Yacht Club? Exactly the same.
it is.
So also trying to find the NFT so you can see the contract, right? Really compare the two, the Bored Ape contract versus the RRBAYC. I pointed this out at the beginning. The name is the exact same. Bored Ape Yacht Club, right? In the contract name, it does not say RRBAYC or RRBAYC Bored Ape Yacht Club. It just says Bored Ape Yacht Club. That was to me the one point that I thought was not great for RRBAYC Poly, right? That it is trying to be tricky even at that level where, okay, if you want to say people can go and verify on chain, you go verify on chain, it still looks pretty damn similar when you look at just that. It takes you looking a little harder. So that was one point I always thought was also, I've looked at 3 different marketplaces so far, and you can't, they're in my wallet, but I can't see them, right? They're blocked.
But it was always shown along with RRBAYC. That is, when the project was referred to, it was referred to as the RRBAYC Bored Ape Yacht Club, and even in the Etherscan token, it had the project name, it had the title, Bored Ape Yacht Club. Immediately under that, or in some cases above, was RRBAYC, the creator name. So it was described to be, it is used in the title for sure, but in the context, there is at minimum a disputed issue of fact as to whether the creation of that would suggest sponsorship and endorsement. And it is also clear that nobody actually ever bought an RRBAYC thinking that they were buying a Yuga NFT. The district court, when going through Sleekcraft, said that did not find that there was any evidence of actual confusion. So the addition of the name...
I don't know if it said that it did find any evidence of confusion versus that there was some offered, but the court didn't need to.
Fair enough, Your Honor. You're exactly right, Your Honor. The district court did not make a determination that there was actual confusion. So, but the error that the district court made happens before we even get into this question that Judge Forrest was asking about suggesting sponsorship or endorsement. The error that the district court made was by finding that nominative fair use was categorically inapplicable, and that is incorrect as a matter of law under this court's decision in Cairns. Cairns says that it is okay to use the name of someone else's product to market your own product if you are using it to talk about theirs. And that is exactly what Mr. Rips was doing. That's why this is just like Toyota. It is just like Cairns, which
and again, given that Cairns is a 2002 case and it predates Jack Daniels by 21 years, the ultimate question that we have is regarding Jack Daniels and whether or not it applies, and given the analysis and the concerns of the Lanham Act, and whether or not those same concerns are present here.
I mean, I would say this about Jack Daniels in that context, Your Honor. This court has decided post-Jack Daniels, this court very squarely decided in Punch Bowl that all of the prior First Amendment law applies other than the very limited issue in Jack Daniels as to whether the mark was being used as a mark. So this court, I think, has already left in place all of the rest of the doctrine, which is another reason why I understand, Your Honor, that these cases are not post-Jack Daniels, but Jack Daniels was focused specifically.
And I'm trying really hard to find this, by the way. Like I'm looking on Etherscan, just so I can find the contract address. I've looked at Rarible and OpenSea and LooksRare and Nifty Gateway. All these places you used to be able to see the RRBAYC Bored Ape Yacht Club NFTs. I don't see them. They used to have their own independent marketplace. It's all gone. It speaks to why NFTs are so great. They still exist. They still exist. They're not actually gone. You cannot destroy an NFT. The artwork associated, maybe, yeah. But the token itself, no. It's forever. Literally forever. It's why I love NFTs so much. But I can't find them anywhere. DGen Hulk, good to see you. Mr. Seed, man, it's so good to see you here, man. On sale any marketplace? No. I won't be shocked if there is something out there, or if they have a Discord where people are trading kind of OTC over the counter. Won't be shocked. Okay, so X2Y2 I need to peek at here. Yeah, that's interesting. They're incredibly freaking hard to find right now. Like, really hard. There's got to be somewhere. I'm going to keep looking here. I want to show them. I want you to see the logo. I want you to see the artwork. and I want to find the contract.
On the First Amendment context of and the Rogers test, and not on nominative fair use. And this court in Punchbowl did say essentially everything else is left alone.
Oh, I got a little.
I'm not sure
something
they
here.
said that it was a First Amendment case, correct?
It was, Your
nominative
Honor.
fair use case.
It was a First Amendment case, not a fair
And
use
so I
case.
think the question is still open.
Fair enough, Your Honor. And it may be that it is worth revisiting, in bank or otherwise, the test for nominative fair use in this circuit. But as the test currently stands, the district court unquestionably misapplied it. And it misapplied it by saying that it's categorically unavailable simply because they were using the name of Bored Ape Yacht Club to market their own goods. The district
Looking
court.
at the elements of the nominative fair use defense under Toyota, New Kids on the Block, one of them is you use the mark only as reasonably necessary to identify the product, and no
That's correct.
further, basically. And here, where the mark is embedded in the name of your client's product, how can you meet that requirement?
Okay, I believe,
Because that
guys.
is true of almost every nominative
believe
fair
this is
use
the contract
case. It is
right
true
here.
of Lexus. The name was embedded.
It says
the
Bored Ape
Lexus
Yacht
mark was
Club.
embedded in the name. It is true of Applied Underwriters. It is true of Food Chain Barbie, the Mattel case, which was another
I
case.
guess I'm coming back to the same question I had. In all those cases, you had a factual context that showed that the person who was referencing the Barbie or the Lexus or whatever, was not making Barbies and was not making Lexuses, was doing something else, was providing a service, was doing a totally different creative endeavor. And that is not the case here.
Respectfully, it is the case here, Your Honor. At least it was a disputed question of fact as to whether that's the case here. Because what Mr. Rips was doing, he is unquestionably a famous artist in the internet space. He's been profiled in this space. And he was very clear that what he was doing was laying out a criticism of Yuga Labs and of NFTs. That is different than what Yuga Labs was doing, which was selling NFTs, period. This was done as part of...
Okay. Now, here's the Ryder Rips Bored Ape Yacht Club. Here's the name right here. Bored Ape Yacht Club, spaces between all of it, and then BAYC. You can see the creator on the Ryder Rips version, contract creator Ryder Rips. Here's the Yuga Labs contract, the Bored Apes contract. Creator of that one is, am I looking at this right? They have a deployer contract. Small differences here, though. The real Bored Ape Yacht Club, the Yuga Labs one, no spaces in the name. They do have a logo. Now, this also was tricky. I think that they had a logo that mirrored the Bored Ape Yacht Club. And it's so small, I don't think people could tell the difference. That might have been removed after the fact, right? I think they had the same logo. I believe, though, guys, again, it's been a bit. And now that we can't go back and check, I believe it had RRBAYC in there. I think it said Ryder Rips somewhere in that. Again, we can't even look. We can't even tell. So yeah, there's a few places that you would have been able to distinguish it. But part of the beauty of NFTs, and really this is all crypto. This is all a crypto, is you need to take more responsibility. You really need to know what you buy before you're buying it. It's fair to say that, and I agree with the Ryder Rip side here, I don't think anybody bought a Bored Ape by accident thinking it was dirt cheap, like $70. I don't think anybody accidentally bought one of these Ryder Rips version, again, thinking they were getting a real Bored Ape. If they did, I still push back and say that is on you as the buyer to be responsible to research what you're buying.
Of this broader artistic project, or at minimum, that was a disputed question of fact that should have gone to the jury on nominative fair use. If I could turn briefly to the issue of ownership, that's another way to resolve this case fairly squarely. Yuga doesn't dispute that they have no registered trademark. They're asserting only common law trademark rights, and they have no such common law trademark rights because of the statements in their own terms and conditions. Their terms and conditions say, quote, when you purchase an NFT, you own the underlying Bored Ape, the art, completely.
It's a good point there, too. Yuga doesn't own the trademark for their own asset. They never did.
They have public statements interpreting that say things like, quote, all IP rights are granted to the member. We have none of those rights. And it was undisputed that those statements were made. It was undisputed that is how the contract had been interpreted in public statements beforehand. And that was, in fact, Yuga's point of differentiation, that they were giving these broad, worldwide, commercial, unlimited licenses to allow entities to, quote, produce and sell merchandise. That is an abandonment, effectively, of trademark rights.
But don't they reserve certain rights? Because, for example, on the secondary market, if these products were resold, then they were entitled to a royalty, correct?
They were not, and they did not obtain any royalty when the products were resold. It is possible to structure an NFT that way. That is not the way that Yuga structured their NFT. It is possible to do that, and some entities have. This license was not one that did that. They claimed no such rights. And
so
that is
the only profit that they made was on the front end,
correct,
and not on the secondary market.
That's exactly correct, Your Honor.
Another important point here. RRBAYC, no royalties. They did not earn anything on secondary sales. Primary sales, yes. Were those sold, guys? Those were minted. If you guys weren't there and didn't see how the mint worked, it was on X. It was Ryder Rips kind of creating them on the spot. No marketplace. You had to request one. You had to tell him you wanted to buy one. And I think you just sent him money. I watched it unfold. I wanted to buy him. I did buy on secondary, but the primary mint was directly with Ryder. But secondary, no royalties. They did not make anything on secondary.
Now, they could have.
Did RRBAYC end up maintaining some secondary rights?
No profits back to the original contract creator on the secondary as a result of the secondary market sales. So that you can set up an NFT that way. These NFTs were not set up that way. And so what Yuga did was gave this away, and we had it gave away all of the trademark rights, and where entities then use the trademark rights, that is an abandonment of trademark rights.
This was a marketplace they set up. 8market.com taken offline,
Might have been
right?
different if they'd
Part
had
of the judge's
registration.
rulings.
They did not have any such registration. And there were dozens and dozens of products, including other NFT collections, to Your Honor's point about these being somewhat more similar than, say, a service, right? There were other NFT collections also using Bored Ape Yacht Club that Yuga did not dispute were sold, in many instances did not dispute were licensed. They're all in the record, 2ER 331, 323, 333 to 412. Dozens and dozens of these other products using the mark. That is absolutely an abandonment of trademark rights and a failure to police. And given that naked license, they can no longer enforce their common law rights.
So I guess on that question, you split out the NFT from the underlying art. So isn't your argument more about an abandonment of the underlying art, not so much abandonment of the NFT?
No, Your Honor, because the contract itself, the Yuga's terms and conditions made clear that it is a purchase of the NFT. So that the NFT itself is what is purchased. So all of the rights to the NFT, as well as the rights to the underlying art, go to these purchasers. And respectfully, as we pointed out in our briefs, the underlying art does include the trademarks, right? It includes, for example, the ape skull logo in the underlying art. So if an entity has the right to use that unfettered, that is exactly the kind of license here. At minimum, again, there was a disputed issue of fact on this. That is certainly sufficient to allow the finder of fact to determine whether or not there is an issue. And then the last thing I would say,
let me ask you, with respect to abandonment, given that Yuga would have actively promoted the brand, hosted these large-scale events, offline social communities, celebrity endorsers, wouldn't that be evidence of the continuation and maintaining of these marks?
I think it may be evidence of the continuation of their marketing.
I might skip ahead to Yuga's lawyer's reply here. Let me see how much longer this part goes.
Activity.
Marketing of what?
But of Yuga Labs as a company and of this sort of club. But that is different than a continuation of the use of the mark so that it continues to function as a trademark, to provide the source identifying role that a trademark is supposed to provide. That is what they did not do. And I would point out again that even if this court were to find, and I don't want to spend too much time on this, I know I'm in my rebuttal, even if this court were to find that these issues were disputed issues of fact, right? So even if it is close, right, at minimum, this should not have been dealt with on summary judgment, and it should not have been allowed to then go toward a jury trial and then have the jury trial removed by this abandonment of legal remedies at the last minute, as this court has said in the Sonner case. That is an inappropriate way to use equitable remedies in place of legal, and that has been essentially the story of this case.
Good stuff, Whirly Girl.
I will reserve the rest of my time for rebuttal if I
Before
may.
you sit down, I have one other question, and
Of course.
perhaps our presiding judge will be a little bit more lenient with time.
So for Polly, the win was just that, the fact that they're not paying yet. That at the very least there's some kind of delay, but also that this is, like you're saying, sent back down to lower courts. It ain't over.
On the copyright counterclaims that your client has brought, I'm trying to, what is your best evidence to show that the providers that took down content were relying on statements that were made in the notices that you challenged that relate to copyright as opposed to
Also, again,
I
interesting,
think
none of the
best
big accounts are
evidence
talking about
is
this.
As to the foundation website copyright takedown, which appears at 3 ER 628 to 629. There's no dispute that was taken down following that notice. And the foundation takedown, the subject line is, quote, Yuga Labs Inc., notice under DMCA, Foundation app. The first sentence of the email is, we are contacting you as the DMCA agent. So when you refer to DMCA in the subject line, refer to it in the first line, and then mention copyright also again, saying that they have the copyright, they represent the copyright.
The district
owner.
court noted that there's things in the record to indicate that what was really being said in those notices was an assertion of trademark rights, and that even the response that providers were giving back seemed to understand that.
So I think at minimum that's a disputed issue of fact. I don't dispute that there are references also to trademark there, but the DMCA is supposed to be this extremely fast mechanism to allow copyright and copyright only violations to be remedied, not trademark, right? And so what they did was they got the attention of these entities by filing a DMCA notice, but in fact had no DMCA rights.
Okay,
That is
so
exactly
Whirly
what
Girl, the win in the
512F
judge, the win would be the judgment's vacated, so that $9 million penalty against Ryder Pauly.
Any assertion of copyright rights.
So the win would be the judgment's vacated, and then there's a trial.
That's a disputed question of fact as to whether they materially relied or
And
not.
so Yuga not talking about it because they don't
that's again
understand
an
it is
error there.
interesting,
The district
too.
court didn't rule on that.
And they may
basis.
not.
The district court said these are not DMCA notices.
Oh,
so
this is gonna go on
512F is
forever.
not triggered.
Wow. Yep.
That was the error because at minimum it was disputed as to whether.
Are you a
they were
lawyer by
512F,
chance,
and
Whirly Girl?
We would say it was also disputed as to whether.
Got a couple
reliance
lawyer
was
friends
there,
in this space too, and I want to get
the
I want to get them on
So I
and
wanna
get into this. We got
ask
some other
something
stories
kind
coming
of
up too.
You have
Kind of
focused
related.
on nominative fair use and really haven't touched at
Yeah.
all on
Whirly Girl says the argument did not go well
so
for
it seems
Yuga.
that the mark at issue, the Board 8 Yacht Club, is a very strong mark. It's fanciful. It's not descriptive. And then you have argued
If
that
Yuga loses, it's a big win for
relying on
art.
the
It's that
enterprise,
simple, which I love.
media case that if by
Honestly, a big win
attaching
for, you know,
RR and
technology, too,
/
I'd argue.
to a very strong mark, that means that there's not a likelihood of confusion or they're dissimilar on that basis. But it seems to me that something very important about that case is that the enterprise mark was quite weak. It was descriptive.
Wow, we're 53 minutes in. We need to crack a couple packs here. All right, we got to crack some Doodles packs. I'll come back to this in a second. A couple Doodles packs. If we hit the merch, the digital stuff, you guys tell me if you want the digital wearables. Let me know and I can give those away as long as it does let me transfer them here in the Doodles app. If not, it's you know, the physical merch I think is the rare stuff. So I definitely want to give that away. Let's do this real quick. Again, it's flying. I dude, it's so entertaining though. All right, we got 2 packs to crack. I don't know what's in the starter pack, by the way. I've not opened that yet, too. Okay, in these packs, we can get... Okay, these are real... they're real shoes. They're physical shoes. I think, again, 200 editions. So that's the real win if we hit that. There's the tracksuit. There's a jacket. Damn, that's sweet. And oh, dude, I don't want to give that away. All right, giveaway's over. Dude, that's cool. There's a holographic jacket. Damn. Whatever. Let's do it. Where is it? Here? Drop there. What? What? What the fuck? Oh, you can't open them yet. Yeah, okay, we can't even crack them. My bad. We'll have to do this next time. Let me crack the premiere pack. I don't even know what's in it, but let's do that. Or you think this has got some value, like keeping locked up? It's too late. No audio? What? What? Okay, our polls. Can I not scroll? Can I not scroll this shit? Come on. What the fuck is this? Okay, I can't, like, kind of arrow through it? Well, let's peek at what that stuff was. Set on my pro... Man, come on. All right, go to my collection. We got the album art. I don't know what's... There's rarity, by the way. There's rarity with those polls. I don't know what's rare or not. Maybe holographic is. Let's peek. I'm just curious. But I don't know where I'm going here. Okay. Let me just check one more thing, and then I'll move back to the court, to the case. Yeah, I can't even click on that pack to see what was rare. So I don't know. I thought the holographic thing was, but okay. Yeah, no idea. All right. Well, yeah, we'll have to do the packs another time. I'm probably going to buy a couple more then. Yeah, just why not? Again, I get addicted to crack and stuff. So, okay, back to the case. I'm going to skip ahead to Ryder Polly's lawyer speaking.
And here,
distinguishing it from the state and on.
Is that comment?
Oh, here he is.
can you,
Or excuse me, it's Yuga's lawyers.
Mr. Gregorian?
Good morning, Your Honors. May it please the court, Todd Gregorian of Fenwick and West for Plaintiff Yuga Labs. I'll take the subjects in the order that Mr. Tomprose presented them, and then circle back to Sleekcraft and anything else the panel would like to hear from, unless the panel has a different agenda. So I think the reason why the court saw this as the unusual case in which you can straightforwardly grant summary judgment is that the core conduct that was challenged was akin to counterfeiting. It was creating identical products, marking them with identical, not modified marks, and then putting those out to market, sometimes under identical advertising of our marks, other times slight modifications, but ultimately in a market where these products trade and retrade with no association to Mr. Rips other than scrutinizing the smart contract. And so when you come to the fair use analysis, this is a question of whether there is fair use for a counterfeit product. If someone makes a copy of a Nike shoe and slaps a swoosh and the Nike brand on it and sells it in Foot Locker and allows it to be sold on eBay, can you come back to the court and say, well, no, my intention in doing that, irrespective of what the reasonable consumer sees when they see it in the marketplace, was to make some sort of sly comment about Nike and their labor practices. And those people who knew me and saw my website elsewhere on the internet, and these dozen or so hearsay emails that I received.
This is where it falls apart.
That acknowledge that
Yeah,
they've
NFT
seen my
buyers are not
website
being
and
fooled by
understand
it. They're
that
not.
meaning. Does that somehow convert? Is that a record on which there is now a triable issue about whether a reasonable consumer walking into Foot Locker sees a counterfeit Nike shoe designated Nike and associates it with an artistic project rather than just a sale of a product in the market as one usually expects?
Well, it seems like you're arguing the likelihood of confusion analysis more than the fair use analysis. And on that point, here, because what you're buying is an NFT and not the art, your analogy falls apart a bit because the NFT is something different than the art.
This is big.
So I would contest the premise, Your Honor, and there is where the record is undisputed that the product that Yuga Labs sells is an NFT with an associated image that conveys rights in that copy of the image, and as well as a copyright license to use the ape that is depicted, as well as other benefits.
Do all of that without an NFT being involved. And because there is an NFT involved, the analysis necessarily is more complicated, it seems to me.
I think, well, I won't opine on whether it's more complicated, but what the analysis is in the fair use realm is, did they use the mark to refer to the product that was sold?
Going back to my threshold question with respect to Jack Daniels, does Jack Daniels affect the analysis at this point?
Absolutely, Your Honor. And
Why?
Because Jack Daniels is a First Amendment case and nominative fair use.
Just got to say, too, this is so much more interesting than the crypto for Kamala thing. Is that it? Crypto for Harris? I think it was Kamala. Because it's real, right? Yeah. As much as there was cool things that happened there, I just had so much trouble making it through this. And yeah, this is a little dry and kind of long, but it's pretty fucking fascinating.
This is a doctrine that's born out of the First Amendment. And Jack Daniels said there is no special protection under the First Amendment when you're using a mark as a trademark to designate the source of the good. Now, I think that principle is already baked in.
And Whirly Girl, why the fuck is nobody talking about it? This is the biggest thing happening in NFTs probably this summer.
That Toyota says, right?
And nobody's talking about it.
What is the standard that they had to meet? Well, the defendant seeking to assert that doctrine needs to show that it used
Holy
the mark
shit,
to
bro.
refer to the trademark.
Dude, great to
And
see you,
they
Milk
need to
Nuts.
show that their use of the mark referred
been a minute. It's good to see you, man.
Labs NFTs.
One of our
not their
OG idiots
NFTs.
here.
And when
Awesome,
Mr.
awesome,
Topper
awesome,
said
man.
That was our burden. That's an incorrect statement. Toyota maintains that threshold burden on the defendant seeking to assert nominative fair use. And that's where things fall down, because yes, there is a technological back end to NFTs, but the question here is, what did consumers on the undisputed record see? And the evidence was that Mr. Rips used our marks in the smart contract. That had the effect of emblazoning the Nike shoe with Nike, marking the fake Rolex watch with Rolex, because it causes those NFTs when they appear for sale in the secondary markets, and when authentication websites and bots that announce to the public what transactions have occurred, it causes all of those things just to read the metadata as Bored Ape Yacht Club and BAYC. And so, to return to my Nike analogy, the situation is actually worse than if you had fake Nikes sold as Bored Ape Yacht Club on this in Foot Locker on the shelf next to real Nikes. It is as if you had the town crier in front of the store, and when a sale of the fake Nike is made, he says, "Everyone, I would like to announce to you that Nike Air Jordans just sold for $5 at Foot Locker." And someone else next to him, an accountant, says, I can verify.
half
that an
agree. Half.
authentic
Like,
Nike
not even
just
half.
sold at Foot Locker for $5.
That on chain it
so,
still says Bored Ape Yacht Club,
The
not
idea
RRBAYC.
that this is, well, to conclude on fair use, there is just no question of fact that those core uses were uses of our mark as a source to designate his product, and that's how consumers saw them. And that's why I don't think we need to get into, the court doesn't need to go beyond that, really.
Whirly,
on
I think
sleek
that's
craft,
it, Whirly Girl.
It doesn't seem
it's
like
not good for them,
the
so
district court
they're not talking about it because of that.
did much analysis of the record, particularly as to the positions of the defense. And in so doing, and given how fact-intensive this area of law is, how can we affirm what the district court did as to its sleek craft analysis?
Absolutely, Your Honor. So I think there's a really clear path here, and it is what did the district court consider at summary judgment, and that is whether the defendants were liable of some form of trademark infringement, right? And it answered that question yes, and it answered that question based on the sale of counterfeit NFTs, right? It said the conduct that is challenged in this case is the sale of products that are made to look like legitimate Bored Apes and then marked with the Bored Ape Yacht Club mark and sold. And the district court has already been affirmed in that regard by a different panel of this court on the state law claims. Different legal context and anti-SLAPP, but nonetheless, that panel said what this lawsuit challenges is the sale of copycat Bored Ape Yacht Club NFTs. And so if you look at the district court's sleek craft analysis, it is tailored to that conduct. So it talks about Mr. Ripps's design of an identical product, including copying over our ape IDs so that his would appear with the same numbering, his marking them with our unmodified marks. And in that, when he talks about use of the mark, right, the district judge says explicitly the use of the mark in the NFT, right? So he is referring to that use of the mark in the smart contract to designate the product. And then he talks about marketing channels, and what marketing channels does he rely on? He relies principally on the secondary marketplaces, OpenSea and X2Y2, where these things go out and appear essentially unaffiliated with Mr. Ripps, but for some very close analysis. And so on the I'm sorry.
One lingering question that I have based on the briefing and the argument that you're making now is your argument makes perfect sense if we're talking about a typical consumer market. I don't think the NFT market is your typical consumer market. And so I guess I come back to, isn't this more complicated?
I love this. Sometimes judges will ask questions that sound like they are leaning one way or another, like the judge is leaning one way. And often that is just to get things on the record, right? They will ask a question. It's kind of setting them up to give an answer that then, again, on the record affects the ruling. This judge saying they think, this definitely feels like they're showing their understanding and actually the way they're leaning. The way she's phrasing it's a little different. And I like it. That stood out to me.
Then you're making it. Because we're not just talking about Nike shoes sitting at Foot Locker. We're talking about something that is, at least in my experience trying to get up to speed in this case, like, what are we even talking about?
Remember, again, the primary sale was done on X. You had to DM Ryder or reply to him in a tweet that you wanted one. Nobody was confused about what they were buying. It is a very different market, a very different audience.
What is
Sure.
an NFT, right?
Sure.
So the people in this market have a different understanding and are coming at this from a different place. Isn't that fair?
So it is fair to say that the body of reasonable consumers is different from the body of reasonable
And
consumers.
would you agree that the
of
sleek
Nikes.
craft test is all about trying to figure out the consumer in our relevant market? Not a generic consumer that buys anything out in the world, but a consumer out there that buys this, an NFT.
Yes, Your Honor. And so let me address how that was handled on this record, which was everyone had their opportunity at summary judgment to prove up the reasonable consumer, and there was no dispute of fact. The products appear identically on an online marketplace. It was undisputed that where consumers go to verify the authenticity of those products, the Etherscan website copied our exact marks. And so someone looking at Etherscan someone who was sophisticated enough to look at Etherscan to verify the provenance of their NFTs would see Etherscan representing these to be legitimate Bored Ape Yacht Club as opposed to a counterfeit. But as to
again,
the
half
reasonable
agree
consumer,
there.
the district court made two rulings, right? One is just that some sophistication is required in this market to verify provenance. And he did that based on the express admissions of defendants. And the second ruling he made is that defendants knew some consumers in this market were likely to be deceived. And there is ample undisputed evidence in the record for that ruling because it is shot through defendants' communications about their project. The people in this market who have been drawn into it by the Tonight Show, Rolling Stone, all the publicity that NFTs were receiving at the time, those are sheeple. Those are sheeple who will not read the smart contract.
There we go.
Oh, they are likely to be confused by our use of the mark on this ape market website that we're designing. Like, these are all internal communications the defendants made among themselves while they were not subject to the scrutiny of the court. And so how does that apply in the larger sleek crack analysis? Well, this court has said the reasonable consumer is not one person. The reasonable consumer is a range of folks. And the reasonable consumer standard is concerned with the least reasonable of those folks. The least sophisticated person who we would also deem a reasonable consumer should not be deceived. And here, it was clear that such a person would be deceived. And that is because, as this court has held, when someone marks an identical product with an identical mark, confusion follows this course, of course. It is also true because the evidence of such likelihood of confusion in the record was undisputed. There were two surveys, one of how the marks appeared on OpenSea that included the modified mark RRBAYC, and there was a likelihood of confusion there. And so the idea that we can argue now, Your Honor, that based on conjecture that RR might be a differentiator, the record is set. The record was that was confusing. When those two marks were together on OpenSea, it confused people. The other survey was about the foundation website and the whole process, the buying process of the NFT. The survey used the foundation website of the defendants after he had begun modifying logos and changing them to make sarcastic comments and points of distinction. And that found a 40% likelihood of confusion. And so while...
Let me ask you, given that on a
That's a
motion for
weird
summary judgment,
statement.
the reviewing court is required to consider the evidence in the light most
Yeah,
favorable
no
to the
part of that was
non-moving
confusing.
party.
None.
And so then here, that would be RIPA writer. And you have evidence in the record regarding how, on the issue of intent, there were disclaimers, there were these artist statements, there were these links to critical pieces, and those aren't even referenced at all. To the extent that they're not referenced at all, how can one reliably conclude that the court considered all of the evidence and considered it in the light most favorable to the non-moving party?
Right. So
I'm going to rewind that for a second because that was important. Also, Whirly Girl, the least sophisticated user would have used a platform that shows Ryder's name as the creator. Yes. You learned of it from Ryder's account. You would have gone to Foundation to buy where it definitely said RRBAYC. If they're talking about secondary, again, I think that's still weird because there's no royalties being made on that. But yeah, the judge here was, again, saying something interesting that I want to make sure to hear it pretty clearly here.
Even referenced at all. It is required.
Used the foundation website of the defendants after he had begun modifying logos and changing them to make sarcastic comments and points of distinction. And that found a 40% likelihood of confusion. And so while...
Let me ask you, given that on a motion for summary judgment, the reviewing court is required to consider the evidence in the light most favorable to the non-moving party, and so then here, that would be RIPA or writer, and you have evidence in the record regarding how, on the issue of intent, there were disclaimers, there were these artist statements, there were these links to critical pieces, and those aren't even referenced at all. To the extent that they're not referenced at all, how can one reliably conclude that the court considered all of the evidence and considered it in the light most favorable to the non-moving party?
Right. So the issue with that is that there is no connection, no necessary connection between the separate website he set up with a disclaimer and reasonable consumers seeing these.
But shouldn't the district court have said that then? It's as if the evidence didn't exist.
Yeah,
Yikes.
Perhaps, Your Honor, but I guess the question for this court is, viewing the evidence in a light most favorable to the defendants, was there liability? Is there liability for trademark infringement? And the district court's ruling that by marking the same product with the same mark and allowing it out into the marketplace in the wild where it would not be associated with this disclaimer, he was committing infringement. And so the question of the disclaimer becomes an issue for the remedies trial, which we had. And
for the remedies trial or for the trier of fact in trying to sort all of this out? Even in as far as the marketing channels, there was no reference by the district court as to this RRBAYC.com being utilized to sell these NFTs, and as if, again, as it doesn't exist. And so if you're considering marketing channels to fairly evaluate the record, then that has to be something that's at least noted.
This is the heart of this case. Now I see why somebody like Paulie's saying this is a win. A key piece of information left out of the previous trial that did matter wasn't even mentioned. Nobody knew it existed. They didn't even consider this. It is a win. We'll keep going, but wow, just wild.
If not distinguished or weighed or considered.
well, I don't think you mash all the marketing channels together, right, and just say, is it the same or different? Those give rise to separate types of claims, and most clearly that is evident in this court's decision in Lindy Pen, which said, look, these things, when they're sold in the store, the branding is completely different. But when they're sold in the telephone market, which is a market where they overlap, they just show up at the office bearing the mark auditor or a variation of the mark auditor. And so the court spliced those two things and affirmed non-infringement on the former and remanded on the latter, and there were...
So Whirly Girl's saying maybe 65% chance the judgment gets vacated for a do-over, and I'm curious where those numbers come from. I have a feeling it's just a guess, and probably a good guess. Do we know when any kind of ruling or comment from these judges is coming?
Follow-on decisions, ultimately a determination of liability.
And Lemon, great point. Hard to comprehend the amount of money wasted on this. I've heard Paulie reference like $20 million Yuga has spent on lawyers and fees and just costs associated with this thing. $20 million for something that, I get it. You're very protective of the thing you made. You feel like you're defending your brand and your holders, but there's definitely more to this.
So the question is, what relevance does the separate disclaimer website have in this record for the facts on which...
Under Sleekcraft, these pieces of evidence I'm referring to, these disclaimers, these artist statements, these sales over RRBAYC.com, are they relevant?
I agree that if this were solely a case about sales about Well, sure, I can concede that. Of course, they're relevant.
And
This
given
is-
how incredibly fact-intensive the sleek craft test is, ultimately, that's why this court, the Ninth Circuit, has instructed district courts to be wary, to just not to grant summary judgment willy-nilly without taking into account the complexities and all the various pieces of evidence.
I'm happy to concede that, Your Honor, but this court also has the rulings in Lindy Penn and Stone Creek when there was an actual trial, and the court directs entry of judgment of infringement, finding that even though many of the fact-intensive factors favored the defense, the fact that the defendant marked the same product with the same mark and allowed it out in the same marketing channels just gives rise to confusion as a matter of course. This is the simple
Matter
case.
of law? Did the court basically uphold the lower court's or the jury's determination versus finding that as a matter of law?
So in Lindy Penn and Stone Creek, the circuit reversed the district court's determination of no infringement because the likelihood of confusion from those three core factors was so strong so as to override all countervailing factors. The reason why this case is the rare case is because, and Your Honors do not see many of these, is because counterfeiters usually fold when they are sued or the case is resolved in its early stages. This is the rare case where the defendants hid behind a claim to be performing art that was contrary to the record and that was ultimately found to be false. With that, we'd ask the court to affirm
I
unless
have
there are
one.
further questions.
I have a question about the cyber squatting claim.
Yes.
I do think the narrative changed. Having been there day one at mint and like knowing how it was talked about when it first minted, and it was very much a fuck Yuga Labs kind of thing, and then it shifted to being about trademark, and then it's shifted to being about like an artistic statement. It has changed. That doesn't mean it wasn't about those things from the beginning, and I missed those conversations. It's like totally possible, but I always felt like the definition of what these were, what they were for, like the intent with them, I always felt like that moved, and maybe it made some of the more recent stuff, or at least their argument here, maybe a little less genuine. But also, I could be wrong about that stuff. I'm just speaking as somebody who was there, like during the mint. I didn't get that from them.
My understanding from the record is that your client has abandoned the ape mark. Is that correct?
That's correct. The cyber squatting determination is based on the board ape mark.
Okay, so then the apemarket.com domain, how does a claim related to that survive?
It incorporates prominently a portion of a famous mark,
And what is that?
the board ape.
So the word ape in ape market is the connection to board ape.
Your Honor, that is the source of confusion at the first step, and of course at the second there.
What's your best authority to say that that's close enough?
So the My Coke and Drink Pepsi cases, there are a slew of cases where minor modifications to the mark and the domain name are sufficient. And the reason that is okay for cyber squatting, where it might not be okay under the higher likelihood of confusion standard, is because the preemption concern is addressed at the back end of the analysis. Someone who...
I guess it's falling apart for me a little bit, because what if somebody out there said, I'm going to register a domain for ape rescue?
Right,
Covered?
and that's where and that's exactly where I'm going. Someone who registers that domain and uses it for such does not have bad faith intent to profit from the use of our mark, and so it's that second part of the analysis that shores up the lower likelihood of confusion standard to ensure that preemption doesn't happen. And
No, that does get me back to the primary intent to mint. It still wasn't trying to confuse. It was absolutely, okay, at that point it was an artistic statement of fuck Yuga Labs. It definitely was. It definitely was. So again, the intent wasn't to profit off Yuga Labs as in a haha, gotcha, I tricked you. It was a fuck Yuga Labs, buy this, and let's like shove it in their face. Like it was that. And that is an artistic statement.
that people are free to use parts of marks in legitimate ways.
Thank you.
And also, they mentioned ape market. That's what we showed earlier. Doesn't resolve, right? Site's dead. And, taken offline because of the confusion. Ape market, they think that means people must assume it's Bored Apes Marketplace, which it's a stretch.
Thank you, Your Honors.
All right, thank you. Mr. Tompros.
Thank you, Your Honors. We heard counterfeit many, many times. That was a disputed question of fact. Whether this was criticism or counterfeit was a key disputed question of fact. The facts have to be interpreted in the light most favorable.
I shit you not, Nilknuz. Okay, if Ryder Rips wins this one, if Jeremy whatever wins this, the most insane performance art this space has ever seen, abso-fucking-lutely, and then I think those NFTs rip. It's exactly why I bought some back in the day. Picturing out years from now when a scenario like this plays out, and if they win, the fucking mad rush there will be to these things when they open up, when they're put back on marketplaces. I bought Funks, Crypto Funks, for the exact same reason all the way again years ago, picturing this would play out exactly this way. It would be one of the biggest cases in the world, and clearly it's not the biggest case in the world. It ain't close, but one of the biggest, most defining cases for our industry it is, and it deserves a lot more attention. And again, I'm shocked it's not getting it right now, although I get it. But I bought them for that reason, guys. And maybe we see it play out. And fuck the value of it. I don't care. I care way more about the defining moments of this space, and this is one. So I love every second of it.
Favorable to the non-moving party, and they were not counterfeits. It certainly when interpreted that way. On the sleek craft question, I heard counsel say that we should apply the least reasonable consumer test. That's not the test. That is sort of where Brookfield was going, but network automation made very clear that where there's expertise in the field, you have to apply the expertise that's in the field. These are NFT purchasers, and there was sufficient evidence in the record that quote, typical NFT purchasers are familiar with blockchain technology and the tools needed to determine provenance. That's ADR 1523. Separate testimony saying the same thing at 3 ER 597 and 98. The typical consumer, people just don't go out and buy NFTs. Typical consumer knows how to figure out and look at the actual creator to figure out what they're buying. On the remaining issue on the sleek craft factors, I heard counsel say there that was no need to consider the RRBAYC.com website and the disclaimer and the artist statement there because it was a separate disclaimer website. Just not true. The factual record makes clear that is where the sales happened, were through the RRBAYC.com website. The district court did not address that. It did not address it at all. And then I think there is, as Judge Forrest was getting at, a distinction here between NFTs and other types of goods. The point, one of the two key points that Mr. Rips was trying to make with his art, as he said, at RRBAYC.com was, quote, clearly defining what we are buying when we purchase an NFT is one of the primary goals of this work. And it is confusing to people what they are, to the general public, not to purchasers, but to the general public, what they're buying when they buy an NFT. You can buy an NFT to the Mona Lisa. You can buy an NFT to Mahler's First Symphony. Because you can buy those things, you do not have the rights to the underlying work here. That is why this is different. And what Mr. Rips was doing was pointing out that having an NFT that links to a monkey picture does not give you rights to the monkey picture. That was a key piece of what he was doing and why it is very different from these kinds of counterfeiting type cases that counsel has identified.
I love it
and
so
then one
much.
final thing on the issue of nominative fair use and the relationship to Jack Daniels. Even if Jack Daniels is affected in some way, it does affect that analysis in some way, it only matters if there's source identification here. And
what
in
a
the
fucking
source
timeline,
identification
right?
cases like Jack
It's
Daniels,
absolutely bonkers.
like the Punch Bowl case, you have indications that the entity that was doing this was trying to sell this as the source. So in Punch Bowl, there was a registration of the trademark, and the same thing essentially in Jack
You're famous,
Daniels with the
buddy.
mark on the back. Mr. Rips never tried to register any trademarks. This was criticism, not competition, not counterfeiting. It was criticism and an artistic project to attack the Bored Ape Yacht Club, not the opposite.
Thank you.
Thank you.
Counsel, thank you for your arguments. They were very helpful. And this case is submitted, and we are adjourned for the day.
All rise.
Absolutely fucking fascinating. I could literally, that's the second and a half time I've watched this. I probably will end up watching it again, honestly. It's super fucking interesting. Again, it's super fucking
This court for
impactful.
this session stands adjourned.
Depending on where it goes next. And it is going somewhere next. I think that's the takeaway here. Most likely going somewhere next. It's awesome. It's a big story. Ain't nobody talking about it. They should be. What are people talking about today? Let me look. Are NFTs back? The 5,000th time somebody's talked about that. Building on Bitcoin. What? No, have you seen anybody else other than Pauly? And I'm sure there are spaces in that crew. But Space is there. And then right here, anybody talking about this big fucking deal? No, nobody's talking about it. Yeah. It matters who you're listening to some degree. And that's not, man, that ain't like really self-promotion. It's just, I think the group here cares about a different thing. We care about that stuff, but we care about, I think, the heart and soul of this place, and that is what's happening here. I love Yuga Labs. I love the Bored Apes. I love them. I do. I really do. I've grown to love them over the past year or two here. I didn't early. I've grown to love them and love their grind and hustle. But this stuff matters a lot, and the implications here are so wide-reaching in artists more than anything else. So it's really important. Appreciate you guys hanging out and just being a part of this. Again, there's not many because most of them aren't paying attention. They should be. This will affect them, NFA, but I'm trying to go find some more RRBAYCs, to be totally honest. I got to find a marketplace. If you guys find them anywhere, hit me with a DM. If I find it, I'll put it on the show. I'm going to run this by Henry and Joe on the afternoon show, too. We're not going to play the whole thing. I won't do that to you again, but I definitely want to get their takes on it. So with that said, I'll be live with those guys. Henry from the CyberKongs, Joe, formerly V-Friends. We'll be live at 4:30 p.m. Eastern Time right here on SlamX official, SlamX.io over on X. Guys, enjoy your day. We'll see you in a bit. Appreciate the hell out of you. We'll see you.